Thank you for meeting with me today, Mr. Dason.
It's my pleasure.
Okay, first of all, I'd like to go over some facts with you, so please correct me if I'm wrong.
Okay.
Okay. You're currently employed by the Run Corporation, correct?
Correct.
And the Run Corporation works in economic research. And this particular project dealt with healthcare usage rates, right?
That's right.
Okay, you received those rates from the Health Statistics Inc. for the price of $150,000.
That's right.
Okay, previously, y'all have been using a program called SPSS for your data analysis, but you heard about Datamagic and thought it'd be a useful program. So with your supervisor's approval, you downloaded the free trial.
That's right.
When you downloaded Datamagic, did you read any disclaimers?
Not that I can recall.
Okay, so you just clicked to agree and downloaded.
Just like everybody else does.
Okay, we'll look into that further. As I understand it, you're happy with Datamagic at first.
Yep, that's right.
What happened the next time you used it?
Next time I used it, all of the data that I had used was corrupted.
Okay, so even when you opened the data with SPSS, it was unreadable.
That's right.
As was all of your backup cartridges. And that totaled about 3 weeks worth of work that was gone.
That's right.
And you couldn't retrieve it.
Not at all.
Okay. I think I have your facts straight. So now let's discuss some of the cases that I think might be helpful.
Okay.
Okay. Typically, the UCC would apply, but since your case involves a free download rather than a sale of a physical good, we'll apply the common law. In St. Peter versus Pioneer Theater, the plaintiff, which was the Peters, attended a sort of raffle at the theater. In order to be considered, the Peters had to be present at the theater and put their names on a list and receive their raffle number. When the plaintiff's name was called, the theater manager said they were just 1 second too late to claim their prize. So the plaintiffs brought suit for their prize money. While a promise to make a gift is without consideration and is therefore unenforceable, the court here held that there was consideration, so it wasn't actually a gift that the theater was making. They held it was enforceable because it benefited the promising party, because the theater was likely to get increased ticket sales, because people had to be present, and the party to whom the promise was made had to be inconvenienced somehow, and it was deemed as a slight inconvenience they had to be present at the theater.
Right.
Because there is consideration in your case, we have a contract, just like in the theater case here. It's a unilateral contract because only one party is making a promise. In the theater case, the defendant determined the adequacy of the consideration, that they just had to be present and put their name on the list. And since the plaintiff did the required acts, which is be present, the plaintiff should be able to recover the prize, and the defendant should honor his promise. In your case, there's arguably a unilateral contract as well. Datamagic promised you the use of their product for the 30-day trial as long as you agreed to their terms and downloaded, which technically you did. Datamagic hoped to benefit by the free trial users liking their product and deciding to purchase the full version for the $2,500. So like in the St. Peter case, Datamagic determined the consideration to be adequate, and thus it should be enforced.
All right.
So hopefully that'll work out for you.
Okay.
Okay. The defense may argue that a Williston-Tramp issue might apply, but I don't think that's the case here. This isn't just a gratuitous promise. Datamagic did hope to eventually benefit from the agreement with future sales of their product.
Right.
Okay, next we have the Birmingham Television case. Here, the Birmingham Television stored some of their television equipment at a storage unit. When they rented the unit, on the back of their receipt, there was a disclaimer. When a pipe burst at the warehouse, or the storage unit, the plaintiff's equipment was damaged, and the Birmingham Television eventually filed suit. The defendant claimed the suit was barred because of the disclaimer on the back of the receipt. However, the court held that acceptance of the terms by the plaintiff couldn't be presumed because the terms hid in nature. Because the disclaimer was on the back, a regular user wouldn't assume to check the back of the receipt for a legal document.
Right.
Hopefully we can apply this to your case, because even if one was to read the box before accepting the terms, the information readily available didn't include the disclaimer for Datamagic. So when you opened that terms and conditions download box, the very first information that you could see was just saying what you were downloading is Datamagic, it's distributed by such and such company, so on. You had to scroll all the way down to the bottom of the document and read everything to actually get to the disclaimer at the very bottom.
Okay.
And as you said, no one actually reads that. However, if this does go to court, you won't be liable for not reading, but the court may treat you as if you have read it. They might expect that you have read it, even though you won't technically be in trouble for not.
Mm-hmm.
Okay. There also may be a Hadley issue in this case. That means that your damages weren't necessarily foreseeable, because technically they could argue that you should have backed up your information elsewhere, but you had been saving regularly, and when you're working with a large data file, like in this case, it should be assumed that it's a foreseeable event for it to be lost, and that be a big damage. But I believe that it's arguable, since it made even files untouched by Datamagic unreadable.
Right.
So it wasn't just that program. Okay, so I believe that's everything. Do you have any questions for me?
I don't think so.
Okay, well, thank you again. I'll keep you posted on any new developments on your case.
Thank you very much.